Hello, welcome everyone. Thank you so much for being here with us today. I'll see you will, yeah. Again, welcome for joining us to this important conversation about the role of the GDPR in regulating and applying to the shiny new thing in town, AI. My name is Gabriela Zanfir Fortuna. I'm Vice President for Global Privacy at the Future of Privacy Forum. But I think that what I am mostly is just a data protection geek. I've been thinking and focusing on this field for very, very much time now. I think my first CPDP was back in 2012 or something like that. And I always keep data protection as top of mind, to be fair. Which is also why it's very difficult for me to introduce this topic right now, because I care a lot about it. And it's been difficult in the past 5 years or so, seeing how data protection and the GDPR kept being pushed a bit to the background of the new legislative framework, the new regulatory concerns, and so forth, because I always have been seeing it as being core to anything that is happening to data that is about an identified or identifiable individual. But I will try to frame a bit the conversation, and then I will introduce our distinguished panelists for today. And I will start by saying that a couple of years ago, I came across this fabulous conference that's organized by ACM, which is the Association for Computing Machinery. The conference is called FACT, and it was created a bit less than 10 years ago. I don't know exactly the year. And it's supposed to deal with fairness, accountability, and transparency of computing systems. And I was so excited to see that, because I was thinking, my goodness, the computer scientists are going to focus on these core principles of data protection law. Of course, I think everybody can recognize them as fairness, accountability, and transparency, which are not only principles of the GDPR, but legal obligations on how we treat the processing of personal data. Only that community seemed to not be aware that already fairness, accountability, and transparency are in fact data protection principles and legal obligations in not only the European Union, but also many other jurisdictions around the world that have adopted data protection law. So it was very interesting to be able at one point also through key thinkers like Mireille Hildebrand, whom you've heard in the opening night of the CPDP, and other scholars, European scholars, who got involved with that conference to bring fairness, accountability, transparency, data protection principles to the world of machine learning and computer scientists doing AI systems, algorithmic systems that want to be fair and transparent and accountable. So you see, for those of us who have been thinking about this field for many years, data protection law is really core to AI, to the extent AI systems are built with the help of personal data used for training, and to the extent that the output of whatever is happening in an AI system results in personal data. One key thing that it seems to be missing a bit in the conversation is also how we have data protection law as a fundamental right in the EU Charter of Fundamental Rights in Article 8, which says that any processing of personal data must be done fairly, for specified purposes, on the basis of a lawful ground, and so forth. But we have that fairly processing of personal data at constitutional level in the European Union. Now, what has been happening from my point of view, starting about 5 years ago, with all of the proposals in the digital regulatory agenda, with the DSA, the DMA, of course, the AI Act, and so forth, if I think about it, feels a bit like flooding the zone. And those of you who are following American politics might know this expression and what it means. But the gist of it is that a lot of developments have been thrown at our community and companies and civil society and academics at the same time. And it seems that this dispersed a bit of the focus on the core principles of data protection that are actually so relevant for developing fair AI whenever personal data is being used. So with data protection taking a bit of a backseat, it was actually very interesting to see at one point in 2023, data protection authorities actually starting to really come back in a way, front and center, with an order that reverberated across the world from the Garante, the Italian Data Protection Authority, which actually ordered OpenAI to stop servicing ChatGPT in Italy because it alleged potential breaches of the GDPR. That came at a time when ChatGPT was really taking the world by surprise. So I would say that was kind of a moment where it became immediately visible and relevant that data protection and the GDPR are actually core to all of these very new technologies and the safeguards that must be embedded in these very new technologies. They're not, in fact, they're regular technologies, as Arvind Narayanan, who was also mentioned by Mireille Hildebrand in her opening night keynote, is laying out right now. So, having in mind this very long background, it is my pleasure to introduce our distinguished panel for today to split the hairs a bit of how the GDPR applies to AI systems. And it's my pleasure to introduce Helena Koenig, who is Senior Vice President for Global Privacy, Compliance Assurance, but also European Data Protection Officer at MasterCard. Valentina Pavel, who is a Senior Researcher for Law and Policy at the Ada Lovelace Institute, based in London. Dermot Goulding, who is the Deputy Commissioner with the Irish Data Protection Commission, and in his current role as a regulatory lawyer, he has responsibility for large-scale statutory inquiries. And Irene Camara, Dr. Irene Camara is Assistant Professor of Cybercrime Law and Human Rights and Research Coordinator at the Tilburg Institute for Law, Technology and Society in the Netherlands. In our first round of questions, we're going to provide a big picture overview, and this is why I thought the best way to start is with Helena, who has to deal with some very practical problems in her daily job life. So Helena, with your hat as DPO, whenever you see an AI system coming into the company to be used for different purposes, or perhaps the company is developing an AI system of sorts, what are some of the key GDPR questions that you have to put on the map that you're thinking about when dealing with that as a data protection officer?
Thanks a lot, Gabriela. Perhaps the first thing I want to say is I was heavily involved in the negotiations around the GDPR as of 2011. And what we are living through now was already known at that time. So GDPR was not thought through by not thinking about the future. Actually, the development of AI was already embedded in it. So you're making a point that is very valuable, is that GDPR is really at the core of how we engage with technology and AI. And so preparing that regulation did not take 2 years or 1 year, as we have seen recently, but it took like 5, 6, 7 years. So it's a really well thought through piece. To give you a bit of background, so MasterCard is a technology company in the payment sphere. You probably have one in your wallet or not. And so AI is used for years already to make sure that payments are safe. Because analyzing data for fraud purposes, when possibly in an anonymized way, is really key to make sure that our payment system is safe and secure. You can imagine that there's a fraud event in India, that gets analyzed to the system, and then the same attack can happen in Europe. Or somebody may be using your credit card number over in, I don't know, Brazil, and you better be sure that that your payments are protected. Or when you are traveling somewhere, you want to be able to use your card. So using AI and computing facilities for fraud prevention in the financial space is very common. It's even embedded and ingrained in European regulations. So we are working with overlapping rules and obligations. So there's a lot of experience in MasterCard around using AI already for a number of years. And so even before the AI Act was even discussed, we were embedding GDPR principles in all of our tooling as part of the privacy by design process, as it was simply called by then. Now we have AI by design and safety by design and innovation by design, but it all comes from that. So the AI governance program as such started in 2019. And I think it's very important to understand that you need to bring together a lot of different people. Document governance, technologists, lawyers, and lawyers from all kinds of areas. The privacy principles are really core in that governance framework. And for us, they actually refer to our technology principles also that we use across the company. Now, perhaps a little bit more about what does that mean for the DPO? And some of you may be DPOs, and I think a lot of DPOs believe and feel that their skill set and their focus on fairness is essential for AI. I would add to that also the DPO's focus on high risk is essential, and the DPO's relationships with regulators and individuals. So the DPOs really focus on transparency and making sure individual rights actually make sense. So the focus of the DPO and the GDPR principles, I would say, that I'm really focusing on is fairness, transparency, and then the risk assessment elements. Of course, other ones are very important too, accuracy, etc., legal grounds. But that's where I think, as a DPO, we can make a big difference. I know there's a lot more to say, but let me stop there for now.
Thank you so much for bringing this into focus. And I think it's at least to me, it's refreshing to know that within the new AI governance structures in-house in the private sector, data protection and privacy remains a core issue that you are thinking about. And you were just mentioning how important the role of the DPO is when it comes to a relationship with regulators. So this is a good segue to go to Diarmuid and ask him about some of the recent thinking that has been going on at the European Data Protection Board and also at the Irish DPC. We've seen a bit what are the practical issues that a DPO is dealing with internally. The DPOs rely on guidance from regulators, and we know that the EDPB has adopted, I still want to say recently, it was December, its first opinion dedicated to AI models, how data protection law applies to AI models. What are some of the key guiding points that are part of that opinion? But I would also want to ask you about the points that are not dealt with in the opinion, because the opinion actually excludes from its scope some points which I found very interesting.
Absolutely. So, hi everyone, my name is Dermot Goulding, and I'm a Deputy Commissioner with the... Sorry, can you hear me?
No.
Sorry. Is that okay? Great. I'm Dermot Goulding, and I'm a Deputy Commissioner with the Irish Data Protection Commission, and it's my first time at CPDP, and it's... sorry, someone putting up their hand?
It's still...
Okay.
It's a microphone thing, it's not you.
Okay.
It's the microphone.
Try again. Hello? Yes. Great, thank you. My name is Dermot Goulding, and I am a Deputy Commissioner with the Irish Data Protection Commission, and it's great to be here at CPDP. It's my first time, and I've been really enjoying the different perspectives that I've heard over the sessions. So it's great to be here today, and to begin, I think, just to say, I absolutely agree that the sense of focus being taken away perhaps from the GDPR as new aspects of digital regulation come online over the last number of years is certainly true, but I think from the perspective of a regulator and our day-to-day work, it's been ongoing in the background, perhaps not with the same level of intense focus as that might have had in 2018. But it is true to say that, again, certainly starting with the Garante, but following on from that EU regulators have been working in the field to respond to the rise in new forms of AI systems over the last number of years. And again, I think it's also very true to say that many of the aspects of the technology that we're talking about are well established and familiar to data protection authorities, be they big data or scraping or other aspects of these systems that we now find ourselves considering. But the Data Protection Commission has as its strategic goals the objectives of driving compliance and also supporting organizations. And that's reflected across many different supervisory authorities, I think. And there was a joint statement earlier this year by the CNIL and the ICO and other global authorities that drew on the difficulties that we experience with regards to AI in terms of the multiplicity of actors, the extent of data, and in terms of how we will respond to this, the objectives of improving transparency, but also reducing legal uncertainty were drawn out. So the DPC has what's called a consultation and supervision function, and it engages on an ongoing rolling basis with the public sector and private sector in Ireland, and obviously Ireland is the focus of much attention in this regard, being the lead supervisory authority for much of the processing that takes place in the context of large multinational companies in Europe. So on the advent of the recent AI systems coming online in Europe over the last number of years, that team has been engaging with the relevant companies, and I think quite productively, it must be said, in a number of cases where in advance of rolling out products in Europe, the DPC was approached and our team was approached, and concerns that were raised and risks to data subjects were identified. And in some cases, the outcome of that was that the products did not roll out at that time, if you think about 2023 and 2024. So against that backdrop, the DPC took the initiative to request an Article 64 opinion under the GDPR of the European Data Protection Board. And I suppose it's notable to think about the value of that mechanism. It's a relatively quick way of getting a regulatory consensus. In 3 months on this occasion, certain issues were clarified. And on top of that, it does lend itself to supporting that objective of regulatory certainty and legal certainty insofar that it's binding as against supervisory authorities at least, and we can be the subject of actions if we don't follow the opinion after it being adopted. In this particular case, the questions that the DPC formulated and put to the board in terms of the issues for the opinion are very much tied into the question of the application of the GDPR per se, but also the principle of lawfulness under Article 5. And those questions, as they were formulated in the opinion, come under 3 headings. in the end. The first relates to the question of how can someone show whether or not an AI model is anonymous, and it must be said that the opinion concerns AI models, that is sort of training mechanisms applied to training data that create a model. It's that aspect of it, and in both the development and deployment sense. So the first part is to do with anonymization, and how can you convince a supervisory authority that you've anonymized the content of a data protection model. The second part relates to the reliance on 6.1f legitimate interests as a legal basis for processing. And finally, there's an assessment or a treatment at the end of the opinion regarding sort of downstream liability by people who are deploying models in circumstances where perhaps the initial development may have questions as to the lawfulness of the processing. So that's the scope of the opinion. The things that were left out, important aspects which are acknowledged, are special category data, issues regarding Article 22 and automated processing, the broader direct question regarding purpose limitation in this context, which is very relevant, and DPIA, I think, was also excluded in terms of it. Now, these topics are touched on to a certain extent insofar as they relate to the issues that are in scope, so you will find some content and discussion of these issues within the opinion, but they're not the direct focus. But in terms of first to start talking about the weeds of it, I suppose, at the outset, the board decides and considers whether or not the content of a model, the parameters of a large language model or something like that, is capable of falling within the definition of personal data. And it's notable that the board, although it doesn't engage in a technical computer analysis of this in terms of computer science, but it's satisfied, the members of the board are satisfied that personal data is capable of being absorbed into the parameters of a model. And so there is not some categorical exception for models that would place them outside of the scope of the GDPR on the basis that they were not personal data, information about identified or identifiable people. And from there, it goes on to talk about the requirements and the technical measures, perhaps, that could be applied that would show a controller that the model was otherwise anonymous, which would also lend itself towards a finding by a regulator, perhaps, that the GDPR was not applicable in certain circumstances. But again, the processing that would lead up to that anonymity will be covered by the GDPR. And so the measures that would be required to reach that standard are discussed. It talks about the EDPB guidelines in terms of anonymization. It discusses the risk approach that the controllers ought to have if they want to achieve that standard of anonymization. And accountability, what ought you do in that circumstance to convince a controller or the authority or other that you have met the threshold in terms of ensuring that nothing can be exfiltrated from your model such that the GDPR would not apply. So I think we're going to perhaps go on and talk about the other details of it later. I don't want to take up too much of the session.
Indeed, and we will drill down on some specific issues in the second round of questions. Thank you so much, Diarmuid, because I think your answer shows not only just how much thinking has been done by regulators on key issues that are related specifically to development of AI models and large language models, but it also shows just how much work is still needed because some of the toughest questions, like processing of sensitive data, has still not been explored. So thank you for that. I would also pick the topic of automated decision-making and Article 22 being scoped out of the opinion, which is very interesting. And I think this is also a good segue for Valentina's input about the question of what is happening in the UK. You have been following quite closely the reform of the UK GDPR, which is part, as I understand, and perhaps it's good to give a bit of background to the room as well, is part of a broader reform of several data-related aspects. But I'm very curious to hear more about that in the UK. And how the question is, how does the development of AI impact the reform conversations in the UK, also considering that the UK does not have a dedicated regulation for AI. So the GDPR really remains core law for AI.
That is very, very true. Can you hear me okay? Yeah? Hi, everyone. My name is Valentina Pavel. I'm a senior researcher at the Lawfulness Institute, and I work in the law and policy team. And we've been following very closely the data reform. But before going into that, because one of the major aspects there was automated decision-making, that's one of our biggest concerns. Let me give you a brief overview of what's happening or not happening on AI as well. So, indeed, there doesn't seem to be any intention for a broad AI regulation in the UK, but perhaps a more narrow regulation focused on foundation models is in scope. And the government has been publicly talking about regulating tomorrow's models, not today's, implying that they're looking to manage extreme frontier risks and not risks known from today's models, which is a discussion in itself. But we might be expecting a consultation of some sort with an AI bill this year. It will first start with a consultation, and then after the response to that consultation is published, then we will probably see an AI bill. However, as you know, the UK government has a very strong focus on pro-innovation and pro-growth. This is the approach to AI regulation in general. And this was first articulated in 2023 with the AI Safety Summit, and later reaffirmed into the AI Opportunities Action Plan, which was published at the beginning of this year. So the UK very much focused a sector-specific and principles-based approach to AI regulation, and the UK government also published an AI regulation white paper, which establishes five principles to regulating AI, and these are the usual suspects. I'm not going to go into them: safety, transparency, explainability, fairness, accountability, etc. So maybe just to also flag out there that the UK government declined to sign the statement on inclusive and sustainable artificial intelligence declaration in the Paris summit at the beginning of this year. So it remains to be seen how those principles are actually going to come into effect. And since then, it has also rebranded its AI Safety Institute into the AI Security Institute. Also on AI, there's a separate initiative in the House of Lords for an AI bill, which was recently introduced for the second time. But this is a private member's bill in the House of Lords and does not have the support of the government. So everything is a bit up in the air in terms of a broad AI regulation. And when it comes to data regulation, this was the Data Use and Access Bill was first introduced 2 years ago. However, previous to this, we had two other similar types of regulation which didn't make it through the parliamentary process. And the intention with the Data Use and Access Bill is, again, to stimulate innovation and growth. But this data bill, as Gabriela rightly mentioned, is much broader in scope than data protection. It includes, for example, digital identity provisions. It includes smart data schemes where consumers can request their data directly from businesses, and the data can go through third parties. This is expanding on the on the open banking scheme into other sectors. So it's much broader there. It also includes a researcher access to data provision, which it's very encouraging. So we very much applaud that initiative. And the bill is in the last stages of parliamentary debate. I think the last sitting is happening right at the moment. So we will see where this ends up. But I want to emphasize this bill because in the context that I just explained with the lack of AI regulation, data protection remains the cornerstone of meaningful protections for individuals, and especially in terms of responding to harms that arise from the development and use of AI. For example, how companies can lawfully use people's data for training AI systems, which I'm sure we're going to go into more details next, but also how people are subject to decision-making informed by AI systems. So what we're seeing is that we have these very core elements of AI still being regulated through data protection, which remains basically the only type of protection. I'm probably going to speak a little bit later about some of the problematic provisions in the data use and access bill, if that makes more sense. So I'll probably leave it here for now.
Thank you so much, Valentina, for this big picture, comprehensive overview on the regulatory aspect of how data protection still remains core, specifically in jurisdictions where there are no AI acts, let's say. And if you think about it, there are more than 140, 150 countries in the world that have comprehensive data protection laws and no AI acts. So I think this conversation will remain key in the AI space. Irene, we've heard from the private sector, right? We've heard from the regulatory perspectives, and we've heard also from a lawmaking type of perspective. From your point of view as an academic, do you still see relevant research in the good old data protection, which has been around from the 70s? What are some of the questions that you still think can be explored? Is there still any research out there that sort of splits the GDPR into the pieces needed to provide safeguards for people when it comes to AI?
Mm-hmm. Yeah, well, absolutely. And I think that's a data protection friendly audience, right? I mean, we got the extension AI in the conference, but it's still very much at the core of privacy and data protection. So I think from an academic, from a research perspective, because we are involved in many research projects with engineers developing all kinds of technologies, I think we also have a difficult task, a DPO sort of task without the machinery of the DPO. So that's a practical challenge that we have in terms of implementing and applying the digital regulations. And I think the GDPR and LED are still the model regulations for many other acts that are coming, not only in the EU, but also, as we know, around the world. And we also saw the example of what is happening when you don't follow the GDPR, like in the AI Act, that we ended up with this interesting compilation of different types of prohibitions, product safety regulation, applying to fundamental rights, etc. So, and other than that, I think looking at the types of technologies and the projects that I'm working on currently, I think what is important is to try to understand that every AI system, even though it might be simple from an engineering perspective, it is always important to look at how principles apply from a data protection law perspective. For example, in my project called Encrypt, what the engineers are doing, they are developing a platform where you apply privacy-enhancing technologies to all kinds of data sets. And this is particularly useful also for hospitals, for example, when doctors want to share information with other hospitals without, of course, disclosing the names of the patients, especially in rare diseases, in oncology. That's very quite easy in a small area to understand who is the patient, right? So even in these kind of cases, for example, in this project, we developed this recommendation engine, AI recommendation engine. And this engine, of course, is trained on different data sets, and how these data sets actually were compiled, and then how they are used in this AI system. It was and it is always a discussion between the lawyers and the ethicists and the engineers. So this ongoing dialogue, I think, and putting it into papers and opening this multidisciplinary dialogue is very important. And as a field of research, but also in terms of practical implementation. In other cases, so this raises the issue of how do you apply fairness, for example, in this kind of systems. But in other cases, for example, we're working with data scientists that are working on cold cases, so they have collaborations with the police, and they try, on the basis of records, telephone records, to uncover correlations in cases that have been unsolved for over 30 years. So this also raises questions not only related to data protection, but also rights of the defendants or rights of people that are included in these databases. And here we see the usefulness of LED or the GDPR, depending on the case, of relating or protecting other rights other than the right to data protection and privacy. The right to due process, for example, or the presumption of innocence. So these are all relevant questions that we're working on from a research perspective. I think one last point that I would like to raise for this initial intervention is the training of models. I think this is something that, in the end of the day, there are decisions that are being made constantly by the people that are developing the models, and we need to train, and we need to have this education and dialogue with the engineers, but also as lawyers, to learn what are the costs, the trade-offs when you actually reduce a data set to what would be desirable from a legal perspective, right? So this ongoing discussion, I think it's something that will continue being in the agenda for the next years.
Wonderful. I'm so happy to hear you mapping out all of these interesting areas of research. I will hang on to how you named the AI Act, which was spot on, an interesting compilation and of very various things. And a part of that interesting compilation, as part of it, we are seeing human rights impact assessments, other type of risk assessments frameworks, and this is the best lead to our second round of questions, where we'll go to drill down a bit in a couple of the key topics. And Helena, I'll come back to you, as you are seeing some actual risk assessments in practice that started with DPIAs, right? Data protection impact assessments some years ago. How do you see a DPIA being relevant when assessing an AI system, be it high risk or not under the AI Act? What can we learn from that process, and what other risk assessments are complicating your life, perhaps?
I'll try to answer your question. Perhaps the first thing to say is that I'm really still learning, and I think we're all really still learning, so it's excellent to have these conversations. So I think from a risk assessment perspective, I see it also with a step back, which is compliance needs what we call a GRC program. So governance, risk, and compliance. And in the privacy data protection area, we are a little bit afraid of that, because we don't like the fact that privacy is also just compliance, which means control frameworks, risk assessments, escalations, reporting, metrics, reporting to the board. Then it becomes more interesting, but we really need to think about also as privacy as certain controls, certain things that people need to do, certain documents that need to be maintained. And the GDPR is interesting from that perspective because it creates accountability. And for some of you who don't know, why this came about, in the old years, there were lots of registration requirements. You had to register this and you had to register that, and so you spent your time on administrative silliness. We see some of that back in the EU AI Act, unfortunately. So accountability actually means you have to have your processes in order, you need to train your people, and you need to have good tools, and you need to be able to prove it. Here comes in the risk assessment. So the DPIA, of course, is a great tool. I think no company limits it to the exact criteria of DPIA. How we all do just regular privacy assessments. Of course, we also do assessments in the incident management space. If there's an incident, we do assessments. Wow, we also have AI incidents coming our way. There's another form of risk assessment. Then we have supplier risk assessment. Very important for privacy, as you all know, because suppliers is the space where the most risk is created. All companies these days are onboarding AI tools. So AI risk assessment in the supplier management space is key, because this is how you enter all these AI risks in your company. And then, of course, we need to think about how are we in that supply chain also informing customers in the B2B space. How do customers know of Microsoft, of other big companies, what AI risks they are taking in? So these risk assessment processes in our space need to be professionalized. And they need to be brought together. The AI assessment, as we have it in MasterCard, is actually two-phased. There's more legal assessment, which is very much brought together with the DPIA and the privacy assessments. And there are more technical assessments like bias testing, bias assessments, etc. So you cannot only look at it from the legal perspective, but you need to all bring it back into the AI governance framework and make sure that the highest risks are being escalated upwards. I hope that gives you some ideas of how I look at risk assessments.
Yes, absolutely. Thank you so much for this, Helena. We'll continue to drill into some of the key questions raised by how the GDPR applies to AI models. And Diarmuid, I'm looking at you because one of the questions that the DPC raised for the EDPB for that opinion was the issue of lawful grounds for processing personal data, and you were particularly interested in how the EDPB assesses the use of legitimate interests as a lawful ground for training AI models. Can you explain a bit what was the conclusion there? What other lawful grounds can be used? How did the EDPB assess this matter?
So the question posed in the opinion by the Irish Data Protection Commission to the board asked how a controller could demonstrate compliance with Article 6.1f as a legal basis for processing in the context of training or deploying an AI model. And the response of the board, the consensus position, was that certain steps could be taken to demonstrate GDPR compliance in the context of, in particular, the LIA, the legitimate interest assessment. In some ways, it's the old assessment that we would be familiar with under the GDPR, but there are new aspects of it as well that emerge in this context, I suppose. So, the overall risk assessment process is the same as described in the EDPB's guidance on legitimate interest that was recently updated. It's first and foremost in terms of the lawfulness and necessity, but primarily, as you would expect, the assessment in the opinion deals at length with the balancing test being the most detailed part of it in this context. And in that aspect of it, again, we see that the balancing test as kind of set down by the EDPB is adopted here in this context, but in an interesting way, I suppose, in that the first aspect of the balancing test, which is the consideration of the interests at stake, is directed to a wider category of rights under the Charter of Fundamental Rights. So it's not just purely, as you might normally expect, privacy and data protection as we might normally be dealing with as a regulator in the context of these companies. The opinion directs the supervisory authorities when looking at an LIA in this context to think also about rights in terms of non-discrimination, health, employment, the right to freedom of expression, a broader set of rights in the context of this assessment than perhaps would normally be. Now, that's not to say that the GDPR doesn't also comprehend those rights in the context of its provisions, but they're very much being drawn to the centre here by the context that we're dealing with. So there's that aspect of it that's interesting, and then it I suppose moves on to the two-part step of the balancing test, whereby it considers first of all the balancing of those rights, but also specific technical mitigating steps that might be taken in the context of demonstration of lawfulness. And I suppose it's worth thinking about those in the context not just of a model as a static system where information is stored. It's thought about in the opinion in terms of the life cycle of the model. So you see sort of measures, additional mitigations that might apply in terms of the training, such as pseudonymization, the facilitation of specific rights of opt-out for a sufficient period of time at the outset. And also you see things in terms of the perhaps deployment of the models in terms of output filters that might be appropriate, steps that might be taken to facilitate rights in that context. And also in a wider sense in terms of facilitation of transparency and understanding here that these mitigations are broader than the pure GDPR obligations under Articles 12 to 14. They're about going beyond to rebalance the rights in the situation, but there's descriptions of potential novelties in terms of, say, model cards to discuss or to describe the key aspects of the model in a way that someone could understand, perhaps publication of information about the training data that went into the model, or perhaps publication of information about the balancing test itself, all of which being ways that the controllers could potentially demonstrate that the balance in terms of processing lies in favour of processing. So that's been the approach of the board, the consensus that reached by the board in terms of sort of clarifying the extent of the obligation. It's important to note as well that these aren't prescriptive or mandatory aspects of the processing. They will vary depending on the level of risk involved in a particular model and the degree to which additional mitigations may be prescribed or necessary, or prescribed isn't the word, but appropriate, will vary depending on the context, and that's also an important aspect of the legitimate expectations test. It's that reasonable expectations of the data subject being taken into account. And in this context, again, it's not just about GDPR obligations and the things you have to tell people about under the GDPR. It's about the relationship that exists between the company and the data subjects, if that's the situation we're dealing with in terms of a training situation, and whether or not someone would reasonably expect information online in perhaps a more sensitive context to be scraped and input into a model. So these aspects of the training and deployment can speak to the lawfulness of the processing and can be addressed to the full life cycle of the model, as it were.
Thank you so much for the points raised. And indeed, the lawful ground for processing is the first problem to be solved, let's say, when training an AI model with the help of personal data. One other obligation, a legal obligation that came across from our first round of conversation was, of course, fairness. And this is also something that I raised in my introductory remarks. Valentina, I know you have been thinking a bit about these issues. How do you see the role of fairness in thinking about lawful grounds for processing when the model is being trained? Does it play, should it play a role in other questions or aspects of how the GDPR applies to AI systems?
Yeah, absolutely. That's a great question. I love that because you made such an important point at the beginning, Gabriela, with Article 8 of the European Charter of Fundamental Rights. which has this constitutional obligation to process data fairly for a specified purpose. So immediately we see the link here with purpose limitation. So that's a directly applicable obligation with fairness and purpose at the cornerstone of processing personal data. But maybe just as a high-level reminder, at the same time, fairness is also it's also incorporated in other pieces of legislation at national level. So it always goes hand in hand with respecting other types of legislation. So in the GDPR, fairness is directly linked with lawfulness and transparency. But the entire architecture of fairness, it's much broader than the lawful ground, because all the elements surrounding it, like data protection by design and by default, data protection impact assessments, accountability, automated decision-making, individual rights, they all need to be taken together and they all need to be respected to create this fairness aspect. So. Fairness, as you all know, means you should only process personal data in ways people would reasonably expect you to, and use it in ways that do not have unjustified adverse effects, so no detrimental, discriminatory, unexpected, or misleading implications for the individuals concerned. So, for example, when it comes to Article 22, just as an example of what fairness might look like, that means individuals must have the ability to contest a decision in a very timely manner. And this is something that we found hugely important, especially in the UK landscape, because an independent legal analysis that we commissioned found that the UK law does not provide effective ways to act against AI harms. So that means people do not have enough information to be able to go to court and to file a complaint. Some of our amendments on automated decision-making are aimed to address some of this. And although there is a welcome specification in the data use and access bill, which says information there needs to be meaningful human intervention, so it has this qualification of meaningful. We go further with amendments and specify what that means. So, for example, a person that's involved in reviewing a decision needs to have a direct authority, first of all, to comprehend, it needs to have capacity, the training necessary to understand what's going on, but also the authority to intervene and to alter the decision at system level, not only at in a specific case. So that's what meaningful human intervention could look like, and it will go a step up in terms of offering more protections in the face of automated decision-making with AI systems. I wanted to go back to a couple of points, if I still have time.
Just a little bit.
Just a little bit.
Yeah.
Okay.
So then we'll have some time at the end for a question.
Okay, that's great, because very shortly I want to point out a few things when it comes to legitimate interests and reasonable expectations, because as Dermot rightly pointed out, there's this three-part test that you need to go through, but there are a few important details there. So you can't have like a very broad, like a very general purpose to just training AI will not pass the legitimate interest test. And while commercial interests can be legitimate interests, they cannot focus solely on commercial gain. They need to have fundamental rights at the center of this assessment. And this is a broader fundamental rights assessment. And it also needs to have a very precise explanations about the purposes. because without this very specific description of the purposes, the developer will not be able to demonstrate why certain types of personal data are needed and how it's actually passing this legitimate interest test. So the ICO, the Information Commissioner Office in the UK, also launched a consultation on generative AI, and something that they are pointing out in their response is that certain respondents have suggested other types of collecting personal data instead of web scraping everything. Some respondents suggested licensing agreements. So this means that the developer needs to show why other methods aside web scraping were necessary or not. So it's a huge it's a huge assessment that's behind this. It's not as straightforward as ticking a box.
And I also very much appreciate how you made kind of an amorphous concept like fairness, and you made it specific and clear in the way it can be used in a very meaningful ways when training AI models and thinking about how the legislative framework of the GDPR applies to it. I will go to Irene now, and Irene, you have literally, I think, just launched a book on standardization in data protection law with the Oxford University Press, which has also been the subject of your PhD thesis. And standardization, as opposed to fairness, is at least looks a bit more concrete, right? Standardization in data protection law. Is that true? Is it more concrete? That's one question. But the key question is whether there is any interaction or impact of standardization in the GDPR and data protection law and standardization under the AI Act, which plays such an important role in the AI Act. What can we learn from the first one when it comes to the second one?
Yeah, thanks for. I was waiting for the standards question. No, I think standards are becoming a very prominent regulatory technique. We see them in all kinds of digital regulations like NIS2, the Cyber Resilience Act, the Cybersecurity Act, a little bit more not on the spotlight, and of course the AI Act and so on and so forth. So I think it's important to know what standards are and what is their value. In the GDPR, they didn't have such a prominent role yet. Well, they did in the drafts of the Commission and the Parliament, but in the end, the final text, everything was replaced with certification, as if they were the same thing. Because the difference is that standards provide requirements, technical requirements, and certification is a way to assess certain technical requirements. There were some political reasons why this happened, but in the end of the day, the GDPR does include some references to standards, and in practice, there is a request from the European Commission to what we call the European Standards Organizations to develop technical standards on the basis of the GDPR, and that has been going on for more than 10 years now. There is a standard on data protection by design and by default, and several technical reports supporting this standard. And what the AI Act can learn from that is, well, what went well and what did not go so well. For example, in the case of the AI Act, we have specific references to harmonized standards, so it's a little bit of a different system, because when you follow a harmonized standard, the same as with product safety, like toy safety standards, you are presumed to comply with the law. So this is a very, very important benefit of complying with standards, which we don't have in the GDPR, which quite understandably so. In the case of the AI Act, So you have this presumption of conformity, and those are voluntary standards, even though they are published, the references are published in the official journal of the European Union, they're still on paper voluntary. So in essence, someone has the right to, a manufacturer of an AI system, a producer has the right to show that they comply with the law in another way. But the tricky part is that, these two standardization initiatives, they need to be developed in parallel and have some interaction. So, and I think the link in the AI Act is Article 10 on data and data governance that makes some references on issues that are being part of data protection standards already. In practice, what is happening is that there are different technical committees at the European Standards Organizations, because there are two different standardization requests from the European Commission, and people started working sort of in parallel. So there is JTC 21, the Joint Technical Committee 21, that is working on AI standards, and there is JTC 13 on cybersecurity and privacy, working on cybersecurity and privacy standards. So those two committees, they interact, so there is a liaison, they observe each other's work, but in the end of the day, they're developing things in parallel. So from a practical perspective, I think there is also this, there is this meme that you say, well, there are so many standards out there, let's solve this issue, and then you just develop a new standard, and then you have one more extra standard doing the same thing. So I think this kind of interaction is very important, because standards, and to respond to your first question, standards have some potential to offer some guidance a little bit more concrete than what we read in the law. However, when the requirements, what the expectation from a technical committee is to develop one standard that covers all cybersecurity aspects of AI systems, then you can understand that this can be a very big challenge for a committee to address in a horizontal standard. So vertical standards, like more sector-specific or applying in different use cases, can be more of help in this case. So this is something that we can learn from the GDPR, because there we also have horizontal standards that are quite broad, and essentially you read the standard and it's a little bit more specific than the GDPR, the relevant provision, but it does not offer that much of guidance unless you then follow another report, etc., etc. So that's an important lesson. But overall, as a message, I think, technical standards are de facto part of the legislation of all these digital regulations, and they have the potential to provide guidance. And from an EU law perspective, there is also some important developments at the Court of Justice of the European Union, because even though those standards are developed by private organizations, the Court of Justice has found in different cases that they form part of EU law. So what this means in practice, and this has been challenged in a landmark case published last year, the Malamud case, for anyone who wants to look it up, it means that, as if you want to contest what is part of the standard, then you should have the right to access the standard. And usually standards, as we know, are sold for a fee. So the court has said that, in that particular case, this organization that was challenging the paywall behind the standards could exercise the right to access to documents of the Regulation 1049 of 2001 and get access to the text of harmonized standards. So for a data protection audience, maybe this does not mean very much, but for standards people, this is very important. And also for people that are working on issues of, what is the relationship between private instruments, such as certification, codes of conduct, etc., and that are used to support EU law and EU policy. I think this is a very important milestone that we have achieved.
And thank you so much for mentioning it. It's quite a significant development, at least the last part you mentioned, particularly considering how important the role of standards is in the AI Act. I feel like we've waltzed through a lot of topics, very big topics and very narrow topics as well, but all of them showing just how relevant thinking about the GDPR and how it applies to AI system is. We have just a couple of minutes for a question or two. Perhaps we can take 2 questions and then we'll wrap up. Everybody wants lunch, I know. Just on time. There's a back there in the...
Hello, and thank you so much for the nice panel. My name is Deborah Ivanova, and I'm a junior privacy and legal counsel at Cover, as well as a student at Tilburg University. And I have a question specifically for the DPIAs. What is your opinion on companies from the more sensitive sector, like, for example, insurance and also the financial sector, that are looking to deploy AI or make use of an AI model? And is a DPIA enough of an assessment in that case to keep everything sit on the safe side? And also, I really enjoy the comment regarding taking a deeper look into the risk assessment. What are some maybe key considerations that you can give to legal experts to pay attention to when they're in the process of a DPIA, analyzing a new AI technology and making a risk assessment for the financial and insurance sector? Thank you.
Thank you so much, Theodora. I don't see other hands, so perhaps, Helena, do you want to take this quickly? Or
I thought it was for the DPA, but I'm happy to try.
Oh.
You can add. So I think when you look at AI, you really need to look at the specific risks. And for each of the areas and domains, the risks will be slightly different. Some companies may have more risks around legal grounds. Others will have real risks around data accuracy. Sometimes it may be about vulnerable individuals. So you really need to focus in on, okay, what are those risks that I'm trying to address? And what are the human rights related to that? And I think that's where the importance is of having a lawyer and not an AI system doing the risk assessment, is to be able to focus in on those specific risks and then think about, okay, what are mitigating activities? What can you do to actually provide more safeguards? And sometimes they will be fully remediating the risk and you will be fully compliant. Other times there are more questions and you should be engaging with the data protection authorities and consult with them. There's one other tool in the GDPR, which is the consultation of individuals when you do a DPIA. And I think that's very interesting because you will get a better sense of what individuals' expectations are. We were speaking about the legitimate interest balancing test. I think it's becoming much more important than we all thought. We really have to focus on it. And so consumer consultations could also give some ideas for that legitimate interest balancing test.
I think this is also where DPIAs bring an additional element of fairness there because of this consultation that's provided for, consultation of individuals, of data subjects that's provided for. Diarmuid, do you want to add a couple of words about DPIAs and the role they have in sensitive sectors like insurance, financial sectors?
Yeah, so I think, in terms of mitigations, I suppose, and the difficulties that are posed by models, I think the question of the facilitation of rights as a way of ensuring that people have a trust in the system that they're dealing with becomes very key, and it's something that I think the supervisory authorities are going to see in detail as people engage with these sensitive issues where there's risks of discrimination arising from the interaction with these companies. So from the perspective of the regulatory side of it, I would expect to see tension regarding the facilitation of rights in terms of the GDPR, which is where we've been focusing so far. But so in terms of mitigating and reducing the impact on data subjects, I think that's an area that we expect to see a lot of activity.
Valentina, please.
Can I add
Yes.
something? I wanted to point out that collecting data through web scraping is an invisible type of processing activity, which means people are not aware their personal data is being processed in that way. So this means people may lose control over how organizations process their personal data and will not be able to exercise their information rights. And invisible processing requires both an assessment of high risk and a DPI.ai. And I wanted to go back to this question of fairness and reasonable expectations. So how many of you expected Facebook to process all of your social media posts for AI training? Raise your hand. Okay, so this gives you an indication that the majority of people did not expect this to happen. So this might be also an indication that the fairness principle kind of falls when you do that. So there needs to be a little bit more consideration when it comes to web scraping, which I think it's still one of the huge problems. But as many of you pointed out, we are still in a very collective brainstorming process, and we need to fix this.
Thank you so much, Valentina. Scanning for one last chance. Well, we have just 30 seconds, so any questions will be discussed over lunch. Thank you so much, everyone. This was wonderful, and thank you to the panel.